Hello everyone. Welcome to this session on dowry and domestic violence. The objectives of this lesson are, firstly, to examine the history and causes for dowry system in India and the attendant evils of dowry harassment and domestic violence. Secondly, to examine the approach of the laws in protecting women from dowry harassment and domestic violence. Lastly, to examine the implementation of these laws in letter and spirit. Let us start by examining the existence of dowry system in India. The antiquity of the dowry system mystifies its origin. The Indian society has witnessed various types of marriage forms. At one point of time, Kanya Shulka was the dominant form of marriage, which involved the bridegroom paying money to buy the bride. This led to a dreadful situation of sale of even toddlers for money. It is not exactly clear at what time in Indian history did the institution of marriage move from Kanya Shulka and dowry system sank its roots. By the beginning of the 20th century, dowry system emerged as the dominant form of marriage across most of India. Broadly speaking, the cash or gifts from the bride's family to the groom's family at the time of marriage was termed as dowry. Some of this may have been considered as stridhana of the woman, and on a positive note, this portion of the dowry gave women economic and financial security in their marriage in those days. It is believed that with the arrival of Islam and colonialism and other factors, the practice of dowry demand by grooms became venomous and became an intolerable burden on the woman's family. Since Indian family system was joint in nature till recently, the bride's parents had to satisfy the entire groom's family with gifts and presents. In many cases, the groom and his family members wanted more and more from the bride's family, and in the process, the woman was harassed for dowry. Thus, dowry added to the causes of already rampant domestic violence against women. The patriarchal mindset of the groom and his family subjected the woman to various other forms of cruelty like abuse, physical torture, etc. for more dowry. Thus, dowry became a major contributor towards violence against women. Dowry is principally a vice afflicting the Hindu community, but its effects seem to have rubbed off on the other religious minorities in India too. But it appears that the problem is still minor in the minority communities when compared to the challenges faced by Hindu women. The dowry system leaves the woman helpless, and the demands for more dowry evolved into a separate stream of violence against women, resulting in dowry harassment and worse, dowry deaths too. The major forms of dowry crimes are cruelty, domestic violence, abetment to suicide, and dowry death. Domestic violence as a form of violence against women is acknowledged only in the recent times. Though this form of violence stems majorly from dowry system, it manifests in physical, mental or verbal abuse, suspicion, various forms of cruelty, etc. The discussion in this session is weaved around how the law addresses the cruelty faced by women within the family, with special emphasis on dowry harassment and domestic violence. Dowry Prohibition Law in India. The first legislative effort to stamp out the evils of dowry system was made during the colonial times with Sindh Deti Leti Act 1939, which had no impact and did not achieve the desired results. After independence, a few state governments passed dowry prohibition laws. As the problem was assuming enormous proportions, a central legislation, Dowry Prohibition Act 1961, was enacted. Let's now discuss the provisions of the Act of 1961. The term dowry has not been defined by IPC but is defined under Section 2 of the Act of 1961. Dowry means any property or valuable security given or agreed to be given either directly or indirectly in connection with the marriage. It does not include dower or meher paid to a Muslim woman. The Act of 1961 punishes any person who gives or takes or abets the giving or taking of dowry with imprisonment up to 5 years and fine up to 15,000 rupees or the dowry amount, whichever is more. To ensure implementation of the Act, dowry prohibition officers are required to be appointed by the state governments. Giving gifts to the bride or bridegroom at the time of a marriage without any demand being made is permitted. Such gifts shall not be beyond the financial status of the person of the giver of the gifts. But the Act provides penalty for directly or indirectly demanding dowry and provides for a penalty involving a prison term of not less than 6 months and extendable up to 2 years along with a fine of 10,000 rupees. If dowry has been exchanged at a wedding ceremony, it imposes a duty on the person who is given dowry to give it to the bride. In Bhai Sher Singh versus State of Punjab, it was held that whatsoever the property is given to the wife by way of gift or will, it will constitute her Sridhana and she is absolute owner. Any person who holds the property of his wife and denies it to her is guilty of criminal breach of trust. Dowry agreements are void ab initio, and if any dowry is received by anyone other than the woman, it should be transferred to the woman. The Supreme Court in S. Gopal Reddy versus State of AP held that under Section 4 of the Act of 1961, a mere demand of dowry is sufficient to bring home the offence to an accused. Marriage in this context would include a proposed marriage also. The burden of proving that an offence was not committed is on the persons charged and not the victim or her family. The Act of 1961, the various amendments to the said Act and various state amendments have certainly brought a lot of change. Some of the change in the system may have been due to the prohibition by law and some of it may be due to the punishment by law. However, despite passage of 55 years and several amendments, the evil practice remains unabated and the dowry related offences are on the increase. Dowry and criminal statutes. To further strengthen the dowry prohibition laws and to stop offences of cruelty against wife, a comprehensive amendment was made to the Indian criminal law in 1983 and 1986. In 1983, Section 498A was inserted in IPC to protect women from cruelty and harassment by husband or his relatives. Section 198A was inserted into the CRPC for prosecution of offences under Section 498A, and Section 113A was inserted in the Indian Evidence Act in 1983. In 1986, a new offence, dowry death, was inserted in IPC as Section 304B by the Dowry Prohibition Amendment Act 1986, which also inserted Section 113B in the Indian Evidence Act 1872 to strengthen the prosecution hands by permitting certain presumptions when the death of the woman takes place within 7 years of her marriage. The offence is punishable with imprisonment for a minimum of 7 years and a maximum imprisonment of life. The offender may be punished with death penalty under section 302 IPC on murder charges and under section 306 for abetment of suicide as well. In cases of non-recovery of dowry by the woman, section 406 of IPC may also be attracted for criminal breach of trust. These comprehensive legislative amendments enabled the conviction of many who were not caught by the Dowry Prohibition Act 1961. However, in Ramesh Chandar versus State of Delhi, the court observed that it was necessary to establish the offence of section 498A IPC to prove the charges under section 304B IPC, and thereafter the presumption under section 113B of the Evidence Act can be drawn. To add to the list, the Protection of Women from Domestic Violence Act was passed in 2005. Despite tightly packed protective provisions, women still face dowry harassment related crimes. The Hindu Succession Act 1956 altered the religious rules by creating a deemed partition upon the death of a Hindu male who had class 1 female heirs. This altering of the succession rules and giving inheritance rights to the woman, coupled with the shrinking family size, may have helped in altering the antipathy towards girl child and sensitizing people towards issues like dowry. It is disheartening to note that in parallel with changing attitudes towards women and dowry, there has been a surge in cases of domestic violence. Domestic violence. Violence against women, both at home and outside, has been the central theme for the women's movement all over the world because this is directly linked to their unequal position in patriarchal society. Domestic violence is abuse by one partner against another in relationships such as marriage and familial relationship. It can be physical, emotional, verbal, economic and sexual abuse. Domestic violence can be subtle, coercive or violent. Domestic violence can be broadly classified as that emanating from dowry demands and for other causes like alcoholism. Often, married women suffer domestic violence in the form of harassment, physical abuse or death when she is thought to have not brought enough dowry. As per the Indian National Crime Record Bureau report of 2012, 8,233 dowry death cases were reported across India. Dowry deaths in India is today not limited to any specific religion, and it is found among Hindus, Muslims, Sikhs and others. It is noticed that there is a surge in domestic violence unrelated to dowry, and this aspect may have led to the passage of a specific law on domestic violence. The act of domestic violence towards women is a human rights violation and serious deterrent to development. The Vienna Accord of 1994 and the Beijing Declaration and the Platform for Action of 1995 have acknowledged this. CEDAW, in its General Recommendation number 12 of 1989, has recommended that state parties should act to protect women against violence of any kind, especially that occurring within the family. The phenomenon of domestic violence is widely prevalent but has remained largely invisible in the public domain. Earlier, Indian women experiencing domestic violence were hesitant to report the crime of domestic violence. Considering it as a personal or family matter, the authorities did not handle it as a legitimate crime or complaint. Introduction of Section 498A in the IPC boosted the women's confidence in the legal system. This section only punishes the perpetrators and is applicable only to a married woman. There is no compensation or relief for the victim under this provision. For this reason, Protection of Women from Domestic Violence Act 2005 was passed to provide remedy under civil law to ensure that the woman was protected and safe in her marriage. Until this act was passed, the redressal was provided in piecemeal under the Anti-Dowry Law and the Anti-Cruelty Law. Protection of Women from Domestic Violence Act 2005. With the realization that the law outlined in IPC only covers only limited portions of domestic violence challenges faced by women, the Act of 2005 was enacted with a view to provide for more effective protection of rights of women who are victims of violence of any kind occurring within the family. The law provides protection to women who is related to the abuser by consanguinity, marriage or a live-in relationship, adoption or a family member from the domestic violence at the hands of husband or male live-in partner or his relatives. The woman can be a sister, widow, mother or a single woman to seek protection here. The complaint can be filed against the male or female relatives of the husband or male partner who committed the violence. The Act itself does not punish the perpetrator of domestic violence against the aggrieved women, but if the case discloses any offences punishable under the Indian Penal Code or any other law or under the Dowry Prohibition Act, the magistrate can frame appropriate charges against the respondent and try the case by himself or commit it to the Sessions Court as the case may be. For the first time, the term domestic violence is defined in Indian law under Section 3 of the Act in a very wider terms than IPC. It is defined in a broad sense to include not only physical violence, but also other forms of violence such as sexual, verbal and emotional abuse and economic abuse. It embraces the situations set out in the definition of cruelty under Section 498A. Domestic violence includes actual act of abuse or the threat of abuse, whether physical or mental, to the aggrieved person. It also includes any harassment by way of unlawful dowry demands to the woman or her relatives. The Act has devised an elaborate machinery to safeguard the interests of women subjected to domestic violence. The Act enjoins the appointment of protection officers who will be under control and supervision of a judicial magistrate of first class. The said officer shall send a domestic incident report to the magistrate, the police station and service providers. The protection officers are required to effectively assist and guide the complainant victim and provide shelter, medical facilities, legal aid, etc., and also act on her behalf to present an application to the magistrate for one or more reliefs under the Act. The magistrate is required to hear the application ordinarily within 3 days from the date of receipt. The magistrate may at any stage of the proceedings direct the respondent and or the aggrieved person to undergo counselling with a service provider. Under Section 18, he is empowered to pass a protection order prohibiting the respondent from committing any further act of domestic violence to the aggrieved person. The magistrate has powers to issue different kinds of orders like protection orders, residence orders, interim orders, monetary reliefs, custody orders or compensation orders as may be required. In Abha Arora versus Angela Sharma, the court held that an order under the Act restraining the respondent from alienating, disposing of or disturbing possession can be made only in respect of a shared household, and even a claim for alternate accommodation can be made only against the husband and not against the in-laws. The breach of protection order by the respondent is regarded as an offence which is cognizable and non-bailable and punishable with imprisonment extending to 1 year or with a fine under section 31. By the same section, the magistrate is also empowered to frame charges under section 498A of IPC and or Dowry Prohibition Act. Section 28 states that a magistrate can establish his own procedure to decide the judgment in order for the victim to give justice. A protection officer who fails or neglects to discharge his duty as per the protection order is liable to be punished with imprisonment vide section 33. The provisions of the Act are supplemental to the provisions of any other law in force. The right to file a complaint under section 498A is specifically preserved under section 5 of the Act. An interplay of the provisions of this Act and the proceedings under section 498A assumes significance in extending effective protection to the victim woman. It is worth noting that while the Act of 2005 was enacted to provide maintenance, shelter or interim finances to a woman subjected to domestic violence or harassment by an adult male, recently in 2016, the Supreme Court in Hiral P. Harsora and others versus Kusum Narottam Das Harsora and others, while hearing a case that had been discharged by the Bombay High Court, ordered the elimination of the phrase adult male from section 2Q of the statute book, calling it discriminatory. Diluting the object of the Act, now anyone irrespective of age or gender can be prosecuted under the Act. Criticisms and views are pouring from all corners, pointing at the apex court judgment. Cases in which there aren't any adult men in the family, like the one that persuaded the apex court to take this step, may be considered on an individual basis instead of altering the law for the purpose. A few words to conclude the lesson. Thus, we see that in spite of the Dowry Prohibition Act, section 304B and section 498A of IPC and Domestic Violence Act, the number of incidences of dowry death, dowry harassment and domestic violence continue to greet newly married women even in 2017. Our first Prime Minister Nehru opined that legislation cannot by itself normally solve deep-rooted social problems. One has to approach them in other way too, but legislation is necessary and essential. Misuse of the laws relating to dowry and domestic violence has been judicially noticed by the apex court as well as various high courts. However, misuse of law by itself is not a ground to abolish section 498A and the connected laws. There are numerous other laws which are misused too, but we don't hear cries for their abolition. Instead of abolition, the approach should be how to make them better so that their abuse is minimized. The social objective behind the law and the need for deterrence should be kept in view. Care should be taken to ensure that the complaints filed with false or exaggerated allegations out of ulterior motives or in a fit of emotion should be curbed. the need to spread awareness of the legal provisions and available remedies, especially in rural areas, both among women and men, is necessary, and in this regard, the district and taluka legal services authorities, the media, the NGOs and law students can play a meaningful role. Law should not sit limply, while those who defy it go free and those who seek its protection lose hope. It is common knowledge that the two major problems besieging the criminal justice system are huge pendency of criminal cases and the inordinate delay in disposal of criminal cases on the one hand and the very low rate of conviction in cases involving serious crimes on the other. This has encouraged crime. The solution to this would be the development of synergy among the judiciary, the prosecution and the police, such that the confidence of the common man in the criminal justice system is restored by protecting the innocent and the victim by punishing unsparingly the guilty and the criminal. Would like to thank you for attending this session. See you again. Thank you.